Good morning, Mr. Dillon. You're here on the Mr. Courtroom case.
Yes, good morning, Your Honor.
All right. I'll call that case for the record. So we're today's the 29th. It's the 30th. We're on the docket. We're on the docket on 22-01581. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. Luke Dillon on behalf of Deshaun Courtroom. We're both present via Zoom and consent to this hearing being via Zoom.
And you are Deshaun Courtroom, sir?
Yes, sir.
All right. And you can hear me all right, Mr. Courtroom?
Yes.
All right. This is the time set for preliminary examination today. How are we proceeding, Ms. Housefield?
Thank you, Your Honor. It's my understanding that the defendant wishes to unconditionally waive his right to hold the preliminary examination. The people would also unconditionally waive their right and ask the matter be bound over to the circuit court on the complaint as filed. At this time, there are no offers to extend, Your Honor, but I believe that negotiations will continue at circuit court.
So, Mr. Dillon, this is an unconditional waiver today?
What Ms. Housefield put on the record is completely accurate, Your Honor.
All right. May I make inquiry of your client, sir?
Yes.
All right. Mr. Courtroom, you understand that you have a right to a preliminary examination today? That's a probable cause hearing in which the prosecutor would prove by probable cause evidence that a crime was committed and a probable cause of the identity of the person who committed that crime. You understand that?
Yes.
All right. And if you waive your right to a preliminary examination today, you'll be waiving your right to have witnesses called in your defense, have Mr. Dillon, who you've retained counsel, to contest any of these charges against you. Do you understand that?
Yes.
All right. And that's your wish today, is to waive your right to a preliminary examination today?
Correct, Your Honor.
All right. I find the waiver. Any questions, Ms. Housefield?
No, Your Honor. Thank you.
Anything, Mr. Dillon?
No, that's fine.
All right. I find your waiver to be freely, understandingly, and voluntarily given. The plea agreement at this time is this is an unconditional waiver, and negotiations are to continue in circuit court. You understand that, sir? Mr. Courtroom, you understand
Yes.
that there's no offer at this time, and negotiations are going to continue.
Yes, Your Honor.
Okay. Okay. Prosecutor also waives their exam today. I accept the waiver. We'll bind this court over as charged to the circuit court. Mr. Courtroom, we lost him.
I think we lost him for a second there, Judge.
All right. I was just going to indicate to him, since he's already waived, to stay in contact with you for any future dates. You'll be the person who actually gets the dates from circuit court.
I'll let him know, Judge. Thank you.
All right. Anything else for the record, Ms. Housefield, on 22-01581?
Nothing for the people. Thank you, Your Honor.
And Mr. Dillon, anything?
Nothing from the defense.
All right. Thank you, Mr. Dillon. Just have him contact you in regards to future dates.
I will. Thanks, Judge.
All right. Thank you. All right. Mr. Courtroom? Just keep in contact with Mr. Dillon in order for any future dates, okay?
Yes, Your Honor.
All right. You're all set, sir. All right.
Okay, thank you.
You're welcome.
No.
So on the record in docket 22-01365, that's people of the state of Michigan versus Derek Fuller Tucker. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
Charlie Petrovich, on behalf of Mr. Fuller Tucker, is present to my right.
And sir, you are Derek Fuller Tucker?
Yes, sir.
All right. This is the time set for preliminary examination in this matter. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant wishes to unconditionally waive his right to hold the preliminary examination. The people would also unconditionally waive their right and ask that the matter be bound over to the circuit court on the complaint as filed. There is no specific offer at this time, Your Honor, but negotiations will continue at circuit court.
And Mr. Petrovich, is that your understanding of what you're doing today?
Yes, Your Honor, that is a full and accurate statement.
May I inquire of your clients of the bind over?
Of course, Your Honor.
Mr. Tucker, you understand that this is the time set for preliminary examination today?
Yes, sir.
The preliminary examination is a hearing in which the prosecutor would have to prove by witnesses that there's probable cause to believe that the felony that's been charged is committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, Your Honor.
All right. And if you waive today, you will not have a preliminary examination. You will not be contesting the charges. Mr. Petrovich is here in order to contest any charges, cross-examine any clients, and bring any evidence forward. You would not have any of those things happen in a preliminary examination. You'd waive your right to a preliminary examination at this stage, and this case would go on to circuit court. Do you understand that, sir?
Yes, Your Honor.
All right. And you do wish to waive your right to a preliminary examination today?
Yes, Your Honor.
All right. I find anything concerning the waiver, Ms. Housefield.
Your Honor, thank you.
Mr. Petrovich? Okay, I find your waiver to be freely, understandingly, and voluntarily given. There's no plea agreement at the time, sir. As you understand, it's an unconditional waiver, but negotiations are continuing in circuit court. Prosecutor also waives their right to a preliminary examination. So stay in contact with Mr. Petrovich in regards to any circuit court dates. Okay, sir?
Yes, Your Honor.
All right. So I'll bind this over on all charges. Anything else for the record, Ms. Housefield?
Nothing for the people. Thank you.
Mr. Petrovich?
Only noting we will sign the waiver to find over.
All right. And I'll also sign the waiver, but I'll give it to you to sign. That's waived on June 30th. And then I can sign up for them. So we're on the record in docket 22-00717. That's people of the state of Michigan versus Lindario Dantes Gowdy. Will the parties please introduce themselves to the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. Jacob Sark, support the Assistant Public Defender here on behalf of Mr. Gowdy. Mr. Gowdy is present at council table. He's standing to my right.
And sir, you are Lindario Dantes Gowdy?
Yes,
All right. This is the time set for sentencing in the matter. And Ms. Houseville, you'd like to be recognized as part of sentencing?
Yes, Your Honor. Thank
All
you.
right. So this time set for sentencing, I will go to the prosecutor first. You've had the opportunity to read the pre-sentence report. Any additions, deletions, or corrections?
None that I know of, Your Honor.
All
Thank you.
right. Any, Mr. Sarts, have you had the opportunity to read the pre-sentence investigation and go over it with your client?
Yes, Your Honor.
All right. Any additions, deletions, or corrections from the pre-sentence investigation?
None, Your Honor.
All right. Ms. Housefield, allocution or comments on sentence?
Thank you, Your Honor. I have had an opportunity to review the pre-sentence investigation and recommendations by Ms. Dehowski, and the people are seeking a longer term of probation. The pre-sentence report recommends 18 months. With the child abuse fourth charge, which is what the defendant pled to, probation is allowed up to 5 years. I think it's important, given the allegations and the charge, that the court have jurisdiction over the defendant for longer than 18 months. There were a few other things that were recommended consistent with the plea agreement. The parenting classes specifically are noted there. That was part of the plea agreement. I will note that as part of the plea agreement, and I will state I was not here for the plea that was done by Ms. Smith. I'm using her notes to reflect, but it's my understanding that part of the plea agreement was also that he received mental health services as part of probation. I note nothing on the recommendations. Even if he were to be screened and follow the recommendations, if there were none, at least he's been screened and someone in an appropriate capacity to make that determination has assessed him. So the people would ask that the court increase the amount of probation as well as add mental health screening and following all recommendations therein.
And Mr. Sarts, would you like to allocate on behalf of your client?
Thank you, Your Honor. Mr. Gowdy is very regretful about his poor decision-making on that day in question. He understands what he did was wrong. He understands that he struggles at times with his temper, that he made a very poor choice of conduct in response to the stress that he was under. And he has learned a tremendous amount from his mistakes. He is actively working on ways that he can address some of the underlying issues here. He is currently involved with pending family court proceedings. He is seeking services through the Child Protective Services Agency. He has been actively participating in that process. So the family court is already requesting through their orders and through his participation in the process to work on a lot of these underlying concerns about not only him, but in terms of the dynamics, in terms of his family as well. To his credit, Your Honor, he has been participating in that programming successfully. Because he is participating in that program, I would request a modification of the no contact order to allow him to facilitate visitations and communications as permitted by the family court, as suggested by Child Protective Services. It's my understanding the goal on that side of things is eventually towards complete reunification, and I would request that this court, allow him to further those efforts along those goals, Your Honor. Respectfully, I think the 18 months will be appropriate here because he will be under the supervision of two courts, Your Honor, but also the family division, the circuit court, as he works through that side of the process. So he will have a significant amount of obligations, but also very strong incentives and good goals and good reasons to complete all his obligations. Of course, ultimately, you know, he wants to maintain and keep a relationship with his children and with the mother of his children. And the pathway forward to that will be through the family court. So Mr. Gowdy, to his credit, does have stable employment, stable housing. He's an excellent candidate to complete probation successfully. And again, he's very sorry, Your Honor, for what happened here. He understands that he has underlying issues that he needs to work on. But again, to his credit, he has a good plan moving forward to work on those goals. Thank you.
Thank you, Mr. Sartz. This is the time for Mr. Gowdy. If you want to say anything, of course, Mr. Sartz has already spoke eloquently on your behalf. So this is the time for you to speak on your behalf if you choose to. There are two courts involved in this right now. There's the family court, and I don't have any control of what the family court is, but I'm familiar with the neglect abuse system in this county. This started out as extremely serious charges: assault, GBA, child abuse in the 3rd degree. I'll rate for the record that the JOS has this as counts 4 and 5. I think this was an amended, added count 6 and 7, but I'm not sure how they do that. So I'm going to make sure that this sentence reflects that we're going on the child abuse 4th under the PAC code 7501365B5, and they have it as count 4. We added as count 6, but I don't know how they amended it. And then they have it as count 5, the aggravated domestic assault 75081A2. I think we added as count 7 for the plea. That being said, I'm not sure how that works, but I want to make sure that that's what the sentence encompasses, and we'll dismiss the rest of the charges.
Thank you, Ron.
Yeah, just to make sure. I am in line with the pre-sentence investigation concerning my sentencing. I'm going to tweak it a little bit, but I think they have some understanding of what's going on. I do have some concerns because these were such serious allegations to begin with, and now we've pled it down to a couple of 1 years. I'm not going to order any extra jail. It's suspended 4 days in jail. There was a Killebrew agreement, no upfront jail. I'll abide by that. All right. So credit is given for 4 days previously served. I'll follow the Killebrew agreement. I'm going to put fines and costs on the child abuse 4th at $100 fines and $100 costs. There's a crime victims' rights fee of $75 on that. There's a state minimum cost of $50. And then the probation is going to be 24 months probation as opposed to 18 months probation at $30. So that will add an extra $180 to the probation because of the extended time. Also on count 5, I'm going to do on that aggravated domestic, I'm going to do $100 fines and $100 costs. There's a state minimum cost of $50. That will be wrapped up in your same probation costs. So it'll be 540 plus 180, which I can do the math on that fairly quickly, but that's 640. That's 720 is what it comes out to. And this will all be on a form for you. So you'll have it, but I am extending probation by 6 months to 2 years of probation. There's a no contact order with Aquavir, Pew, and Sardaris Porter. And I'm gonna indicate for the record that whatever family court finds in regards to, and so you're under the control of the neglect abuse court, whatever they find in regards to over supervised parental contact, all right, which is usually weekends or something along those lines with somebody there to watch it, because they have a different goal. Their goal is to reunify the family, okay? That as long as they okay that with the probation officer, that can start. But I'm going to say that starts after about 3 months, okay? That series of just to give some time. So I'm gonna say that I will modify the no contact order to be at the discretion of the probation agent and at the discretion of the family court, okay? Because that's what they do, okay? So I'm gonna modify the no contact order to be at the discretion of probation officer, and family court. Thus, if family court sets a supervised contact, and they contact your probation officer, and as long as it's supervised, that can happen, okay? I'm gonna put supervised contact at this point. So no assaultive or threatening behavior, no use of alcohol, marijuana, or controlled substance without prescription. Submit to random PBTs and or urinalysis if required. And under the other, they've requested a parenting program. As long as the parenting program is coincides with what family court wants, I find that acceptable. I do think that there should be a mental health screen, all right? So I'm going to indicate and a mental health screening. So the whole point of the sentence is to make sure this doesn't happen again, right? You start out with really serious felonies, and now we've come to 2 misdemeanors, but I think they reflect the nature of these charges, which is child abuse, which the court takes very seriously, and so does neglect abuse, and then aggravated domestic violence, which is the offensive touching of an aggravated offensive touching of a person who you've been in a relationship with. And I think we can only infer that this is all from the same family. So obviously, 2 years in front of me and then in front of family court, the inclination is that this doesn't happen again. Okay, that this just does not happen again. Because if it does happen again, the consequences are drastic. Okay, the circuit court has the power to terminate your parental rights, and that's their power. They do so by clear and convincing evidence, and they can do so within a year of the filings. So that you're on a sort of sentence to them right now. And then you have me dealing with the criminal charges. So let's just make sure that we get the unification of the family and that you complete your probation. And then the rest is out of your hands. Do you understand that? If you do what you can do, and in that essence, that's to take care of all of this. All right. So that's my sense. That's my sense today. Any questions for the record, Ms. Housefield?
No, Your Honor, thank you.
Anything, Mr. Sarks?
Nothing further, Your Honor.
All right. Mr. Gowdy, good luck, okay? If you can, Ms. Housefield,
May I check the witnesses, Your Honor?
you may,
And then
you may.
Advise the court.
All right,
Thank you.
thank you. Ms. Nagel, what case are you here on?
Here on David Richards, Your Honor.
Like Megan Nagel?
Matt Nagel.
All right, I have a Megan Nagel in the courtroom. Is that any relation? All right. So, Ms. Nagel, you're free to stay here, but you can also watch on YouTube.
Hello?
Are you in the courtroom, Nathaniel?
What's,
Mr. Nickel, Nathaniel, step out for just a moment.
Okay. When someone can, if Mr. Fisher and I could be put in a breakout room, that would be appreciated.
Okay, I'll let you know.
Thank you.
Thank you. In docket 22-01619, will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
And ma'am, you are Kelly M. Gamblin.
Yes, sir.
And Ms. Gamblin, this is the time set for preliminary examination today. I have in the register of actions, I have it indicated that you were going to request a court-appointed attorney and that it was denied. We left it on for prelim with the understanding that you'd have counsel today. It's my understanding you don't have counsel today.
No, sir, I do not have counsel today. They're
Okay.
still trying to, I'm sorry. They're still
Go-
trying to
go
reopen
ahead.
the case. They're trying to reopen my file with the public defender's office. I was on the phone with Ashley Griff this morning. So I'm hoping that the sheriff eventually gonna pull through for me.
Okay. Ms. Housfield, do you have witnesses today?
I did not intentionally call in witnesses,
Right.
Your Honor, because when I checked both my file yesterday to see if we had received an appearance and JIS to make sure that perhaps the court received one, but not the people, we had not. I presumed it would not run today, and so I intentionally, Your Honor, did not call in witnesses.
Right. No, I didn't mean to put you on the spot on that. I mean, my greatest concern is that we're set for preliminary examination and you don't have counsel. That's my greatest concern. And now we're running into a 21-day problem, which is that you have a right to a preliminary examination within 21 days. And I can adjourn it for good cause. And not having a lawyer is good cause for a preliminary examination. What I would like to do is, so that we understand that you have time to get a court-appointed attorney, is that you're either explained from one of our public defenders or Ms. Housefield that you have a right within 21 days. Okay, you have a right to a preliminary within 21 days. And that if you waive that right, you don't waive the right to a prelim, you just waive the right to have your prelim within 21 days. And that would give you time to go seek counsel. And that's what we want. We want you to be represented before you have a preliminary examination where these charges are contested and you can cross-examine witnesses and all of that. Do you understand that, ma'am?
I do, and thank you for clarifying that for me.
Yeah,
That was-
that's one of the reasons why I had you come in, so there wouldn't be no misunderstanding. We want you to have a lawyer, all right? I want you to have a lawyer. I think Ms. Housefield, the prosecutor, wants you to have a lawyer. That's the whole purpose. We have people from the public defender's office who tell you, I'm just talking about procedure process, okay? And that's to make sure that you understand that that we're covering all your rights in this, all right? Nobody wants to have you do a prelim without a lawyer, at least talking to a lawyer. But it's ultimately up to you, all right? You can talk to you can talk to Ms. Housefield. She can explain you the same thing, you could. I'm sure Ms. Sutter who's a public defender in this courtroom, would tell you the process. This is just a process. I would adjourn it today for good cause, because I think not having a lawyer is good cause. We don't have witnesses today, but it's ultimately up to you. Do you understand that?
Yes, sir.
Would you like to talk to Ms. Housefield or maybe Ms. Sutter briefly about the process and then come back?
No, sir, I would like to be granted me an adjournment, so that I do have time, because I do need to be represented after like.
All right, and then whoever you end up getting as an attorney, I want them to make sure that they contact Ms. Housefield so she knows what's going on, or the representative from the prosecutor's office assigned to this courtroom.
Yes, sir.
So I find there's good cause to adjourn this without you waiving 21 days, okay? At this point in time, I find there's good cause, and that's what you're asking me to do, correct?
Yes, sir.
Ms. Housefield, anything?
No, Your Honor, except that with regard to the adjournment, I would however ask, because there has never been contact with an attorney, that this be set for a PCC and a preliminary examination.
I think that's fair.
And for the record, I will be retaining this file, so I will be the person on it that.
Oh, all right.
What is the PCC? Your Honor?
It's a probable cause conference on the prelim. So it's what we had last week saying, all right, we're gonna have a prelim next week. Let's make sure that the attorneys meet so that we can work out any issues, so we know if we're going to prelim or not, all right? And that's what we did last week on this case. But but we're not able to do the prelim today, and Ms. Housefield hasn't had the opportunity to speak to a lawyer for you because you haven't had a lawyer. So we'll just set it for another probable cause conference and another prelim examination. I'm just gonna find good cause to adjourn today. So you're 20, so you're outside of your 21 days, but they're intact for good cause. Do you understand that?
Yes, sir.
All right. So we're gonna adjourn this matter, and the only reason I had you come in today was because I wanted this all on the record, so there's no misunderstanding, because sometimes on Zoom, it's not the clearest form of communication.
No, there was
All right.
definitely a misunderstanding this
So-
morning because I was on Zoom at 8:30.
Yeah, so I understand that. I just want to make sure there's no misunderstandings.
Yes, Your Honor.
So I'm gonna adjourn for good cause. Defendant is continuing to retain attorney. And you do have an application with the Public Defender's
Yes,
Office.
sir, I do.
And we'll set another PCC for
July 15th at 8:30.
July 15th at 8:30. And the preliminary examination,
July 22nd,
July 22nd,
also at 8:30.
also at 8:30. Any questions, Ms. Housefield, on what the court indicated?
No, Your Honor, thank you.
Ms. Gamlin, do you have any questions of the court today?
No, Your Honor.
All right, these two dates are important. You'll get notice, July 15th at 8:30. Make sure the new council has it. And then July 22nd at 8:30 for the preliminary examination.
Yes, sir.
All right, thank you, ma'am. Have a nice day.
You do the same.
Thank you for appearing today.
Thank you.
Sounds good.
Thank you, Your Honor. Jacobson is going to be a waiver to circuit court, and Galinda's is going to be an adjournment request. So I don't, whatever,
Let's do,
actually, I don't see Mr. Blackman. So maybe do Galinda's, please.
all right, let's do Galinda's.
I'll get Mr. Glenn, your honor, just a second. It's in the hall.
All right. All right, we're on the record in docket 22-00155. That's people of the state of Michigan versus Gustavo Galindez. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
Good morning, your honor. John Abbott representing Mr. Galindez. He is present and standing to my right.
And sir, you are Gustavo Galindez?
Yes, sir.
Ms. Housefield, this is time set for preliminary examination. How are we proceeding today?
Thank you, Your Honor. I had the opportunity to speak with Mr. Abbott this morning. He indicated to me that Mr. Galindez is scheduled to be sentenced in August in Eaton County. Due to that information, as well as some potential impact that that sentence may have on this case, we are still continuing our negotiations. We would ask for a brief 2 to 3 week adjournment in order to take into consideration that impact on my case going forward. And I believe that Mr. Abbott would have no objection to that adjournment.
And I don't have a 21-day waiver in the file. Would your client be willing to waive his 21 days at this
Yes,
point?
Your Honor.
All right. And is that your understanding of the status of the case, Mr. Abbott?
It is, your honor. It looks like he's going to be sentenced to 9 years.
Okay.
No,
So that would have some impact on how we settle this case.
it's-
All right. Sir, I'm gonna go over your rights in this case. You have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that?
yes,
And your preliminary examination means that the prosecutor would have to prove by probable cause evidence that a crime was committed, the crime alleged in the file, which is a felony, and that the identity of the person who committed that crime, which they're indicating is you at this point in time. You have the right to contest those charges. Mr. Abbott's representing you from Public Defender's Office. You could cross-examine any witnesses, anything along those lines to have them proved by probable cause evidence of the charges in the file. Do you understand that?
Yes, sir.
And if you waive your right today, you're not waiving your right to a full preliminary examination. You're just waiving your right to having a preliminary examination within 21 days. Do you understand that?
Yes, sir.
Are you willing to waive your right to a prelim within 21 days today?
Yes, sir.
All right. And do we have a new date?
July 22nd.
So is July 22nd? Or do we need a further date, depending on the sentencing date?
A little further wouldn't hurt at all.
Yeah, I think a little further would probably be safe. Maybe a week or 2 weeks.
I'm gonna be out the following week, Your Honor.
So maybe an
additional 2, so beginning of August.
let's do beginning of August. August 5th. 5th at 8:30. That'll be the time set for the preliminary examination. Any questions, Ms. Hoskins?
No, Your Honor, thank you.
Anything, Mr. Abbott?
No, thank you.
All right, good luck, Mr. Galindez. This is all on file 22-00155.
Thank you.
I'll be right back.
All right. Thank you, Ms. Housefield.
Thank you.
Mr. Fisher, you had the opportunity to speak with your attorney in a breakout room?
Yeah,
All right, just stand by, sir. We're in the Zoom courtroom and we'll wait to hear from your lawyer, okay?
okay, Your Honor.
All right. So we're on the record. We'll do the first one on 22-00749. That's People of the State of Michigan versus Michael Kelly. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Luke Goodrich from the Public Defender's Office here to represent Mr. Kelly.
And this is the time set for 9 o'clock for prelim on file 749 on Mr. Kelly. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant is not present either in person or on Zoom, although the preliminary examination does require an in-person appearance. At this time, Your Honor, the people would ask for a bench warrant bond forfeiture.
Any comment, Mr. Kelly? I'm Mr. Goodrich.
Your Honor, I would just state that on the 26th, when we held the of May, the 26th, we had the PCC. We asked for about a month to look into a drug court. He was released, I believe, a handful of days after that. I have not had any contact with him since that time.
Yeah, I have the ROA indicates that he appeared in person on May 26th, waived his 21 days, and that he was aware that the prelim was to be held today at 9 a.m. And with bond conditions. So I will grant the fail to appear bench warrant bond forfeiture on file 22-00749 in regards to Mr. Kelly. Similarly on in docket 22-00750, will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Luke Goodrich from the Public Defender's Office here to represent Mr. Kelly.
And this case is also set for prelim at 9 a.m. today. Ms. Housefield, how we proceed?
Thank you, Your Honor. It's my understanding that the defendant is not present either in person or in Zoom, although the preliminary examination does require an in-person appearance. At this time, the people would ask for a bench warrant bond forfeiture.
Mr. Goodrich.
Your Honor, again, I have not had contact with Mr. Kelly since his release from the jail.
Once again, for the record, we had a probable cause conference on May 26th in which Mr. Kelly appeared in person. He was given this date as the date for the preliminary examination. He has failed to appear, so I will grant the bench warrant and bond forfeiture asked for by the people. Anything else in the file in 22-00750, Ms. Housefield?
No, thank you, Your Honor.
Mr. Goodrich.
No, Your Honor.
Thank you. Is that Mr. Jacobson?
It is.
Okay, we're on the record in docket 21-02813. People of the State of Michigan versus Robert Jacobson. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. John Abbott representing Robert Winter Jacobson. He is present and standing to my right.
And sir, you are Robert Winter Jacobson?
Yes, Your Honor.
All right. Ms. Housefield, this is the time set for preliminary examination. How are we proceeding today?
Thank you, Your Honor. It's my understanding that the defendant wishes to waive his right unconditionally to have a preliminary examination. The people would also unconditionally waive their right to hold the examination and ask that the matter be bound over to the circuit court on the complaint as filed. Negotiations will continue at circuit, Your Honor, although the people did make an offer to plead to an added count 3 of child abuse in the 3rd degree.
And that's to remain in circuit court.
That is to remain at circuit court, Your Honor. That is still a felony.
And Mr. Abbott, is that your understanding of the preliminary examination today?
It is, Your Honor, yes.
Okay.
However-
Go ahead.
Before we waive out of your jurisdiction and into the 30th Circuit, Your Honor, I'd like to raise the issue of the bond conditions, including a no contact order with his son Noah. And the reason I'd like to do it today is that the sooner we get reconnected with Noah, the better for both the father and son. And it might take several weeks or a month before I could get in front of the judge in 30th Circuit.
Ms. Housefield, do you have any objection to discussing the no contact? I assume it's a no contact order.
It is.
I have no objection to discussing it. I have a position and
Okay.
object to their motion.
Okay. Well, let's do the waiver first and then do the bond condition, or would you prefer to do the bond condition and the waiver?
Either way works.
All right, let's do the waiver first. May I inquire of your client?
Yes.
Okay. Sir, you understand that you have a right to preliminary examination within 21 days. You understand that? You waived your right to a prelim within 21 days, so you still have a right to a preliminary examination. And a preliminary examination is where the people would have to prove their case at a probable cause standard that the felonies that are in the file were committed, and the identity of the person who committed that, which is you, which is the allegation is you. You would have the right to be you would have the right to counsel, which is Mr. Abbott, and he would have the right to contest all these charges, cross-examine the state's witnesses, and then provide any testimony if necessary. You understand that? And you're waiving that right to a preliminary examination today. You understand that this is going on to circuit court where there'll be further negotiations. All right. Any questions concerning the rights of the defendant, knowing that this case will proceed in circuit court? Ms. Housefield?
No, Your Honor, thank you.
Mr. Abbott?
No, thank you.
I find your waiver to be knowing, voluntarily, and understandably given. I'll bind this case over on all charges as filed. It's an unconditional waiver. There is a child abuse felony offer on the table still to remain open. My understanding is the prosecutor also waives their right. And so in regards to this, stay in contact with Mr. Abbott, and he'll give you any further dates in circuit court, because they'll set them there. All right.
Yes, sir.
Ms. Housefield, would you like to be heard on bond?
All right, yes, Your Honor. The defense is asking that the no contact order be lifted with the minor child, in this case, who's the victim. Based on the charges, Your Honor, and the allegations that are before the court, not specifically within the charges, but this is charged as an assault, strangle, felony matter, Your Honor, and then a misdemeanor child abuse fourth. I put forth as an officer of the court, Your Honor, that there were not used in the offense, but there are at least one, if not more, weapons, guns in the home. The defendant is a vet, and so understandably why there may be weapons, but the fact that there are weapons involved, and that is what the child was concerned about based on the defendant's level of intoxication at the time, is how this case started. The people have some pretty serious concerns about lifting a no contact order before there's any type of oversight in the criminal matter. I do understand, and I am fully aware of the abuse and neglect case. He did plea in that matter. He is in the jurisdiction of the court. My understanding from the abuse and neglect prosecutor is that he is making appropriate gains and movement forward in that case. The people are not alleging anything to the contrary, but we still have a very serious criminal case outstanding. And so I understand what Your Honor did in the previous matter that involved a child abuse and both the family court and the criminal system, but that's in a case where a plea had been reached. There was set to be probation. There was going to be jurisdiction of two courts, and I view this a little bit differently. So that I would ask that at this time, until there is some resolution or at least a movement on the criminal case, I would ask that the court at this level not change the no contact order.
Mr. Abbott.
Thank you, Your Honor. And I certainly respect Ms. Housefield's position. However, there is a strong presumption of innocence. It's still intact here, and there's been no evidence provided to any judge or jury regarding the criminal allegations here. I have provided to Mr. Nueves, and I'm hoping that he's provided to you, an email string where I contacted the DHHS people that are petitioners in the child abuse case as well, and they they're in contact with the people at Eagle Village, which is where Noah lives right now, and the therapists at Eagle Village feel, as well as the DHHS workers feel, they would be in the child's best interest to reestablish contact with his father. And that essential father-son bond, it's a very important part of his life, and that any contact at this point would be supervised by the therapist. The village is way up by Claire, and here is Mr. Jacobson in Ingham County, so the risk of harm to the child is very low. I think the benefit to the child is substantial if he can just hear from his dad and they can start talking to each other. And although there's an allegation that there were guns in the house, I don't think there's any allegation that there was a threat of use of that firearm towards a child. So I think in the child's best interest, eliminating the no contact order is a good idea, and I'm confident. And as she mentioned, Mr. Jacobson is participating and taking this seriously, and that alcoholism underlying the whole event. He's in AA how many times a week?
9 times a week. IOP 9 hours a week. I reside at Sober Living at Safe Harbor. I successfully completed 90-day program at Holden House. I do have 2 sponsors and accountability partners as well. All documented, Your Honor.
So he's definitely on the right path. He's taking this seriously, and I'd ask the court to remove the no contact order with Noah and leave it in the discretion of the therapist and the DHHS people to move that at a speed that they feel is appropriate for the child's safety.
It's an interesting concept here that the 2 files today have similar issues concerning dual jurisdiction with district court and with family court and the supervision involved. I do believe Ms. Housefield makes a good point that this case is not at the same level or not at the same resolution as the other file. So I'm willing to somewhat moderate the no contact order, but I'm not going to lift the no contact order. Understanding that both courts have different purposes. My purpose is to make sure that this case proceeds to circuit court and that victims are protected and that your rights are protected also. The circuit court family court case is seen as to help reunify the family. And right now we're at odds. Okay, there's two different courts with 2 different goals. I understand though that the circuit court has a different goal in regards to having you see your son, and I think that's a good goal. Okay, but it has to be supervised, and it has to be and there has to be an order that this case is not talked about in any way. And they can decide who supervises it. And it's Judge McCormick, who I know in family court. Certainly, she's going to make sure that this case is well protected because we don't want any infringement concerning the victim in the case, who happens to be, part of your family. So I'm going to set bond conditions. I'm not going to lift the no contact order. Okay. I will modify the bond conditions that D can have supervised contact at the discretion of the family court Eagle Village. Ultimately, it's the judge's call. after consultation with pretrial services. If they find that, if they find that the goals of that court will be helpful in having some contact with the son in a supervised setting, I'm gonna let the family court make that decision. Okay? Judge McCormick can make that decision. But other than that, the contact order stands. No contact order stands because it has to, all right? Until this case has some type of resolution. Any questions, Ms. Houseville?
Your Honor, you mentioned before stating how you would modify bond that it was going to specifically include an indication that the defendant and the child should not discuss this case. I think that's important to be included in the order so that as the next level looks at this, there's a very clear understanding that that is part of the condition. Because I don't want to have, and I'm not suggesting it will occur, but it is possible that there may be some pressure or suggestion that the victim not want to proceed in the criminal case. And I would hate to have that happen as a result of potential reunification and telephone conversation or supervised visits.
If I wasn't clear, Mr. Jacobson, if you are able to, in the court orders, family court orders supervised visitation, there's not to be any discussion of this file or these case or these facts. All right. All right. Anything else, Ms. Houseville?
No, Your Honor, thank you for that.
Anything, Mr. Abbott?
I thank you.
Nothing further? All right. Well, we'll leave that in the discretion of the circuit court, the family court. My order allows that to happen if they choose. Okay.
Thank you.
So that's all for the record in 21-02813. Good luck, sir.
Thanks.
Ready when you are.
Okay, I think I am too. I think we're gonna do a plea and then, yeah.
Mr. Nichols, you're here on Mr. Fisher.
Yes, I am.
All right.
Okay.
No, that's fine.
The initial and the supplemental.
Mr. Fisher was here. It's okay with the misdemeanor. Where's Mr.? I don't see Mr. Fisher. He was here and he left us. I take it this was going to be a misdemeanor plea?
That is correct, Your Honor, to a
Larceny.
93-day B&E from a vehicle less than 200.
Right.
Yeah.
Yeah. We just he was here and we lost him.
Maybe do a different one then while we wait.
Yeah.
Mr. Gillian, Your Honor, is going to be a nollie. Sorry, I'm looking wrong. Mr. Gillian is going to be a nollie. I don't have witnesses.
Okay, Mr. Gilliam.
That is correct, Your Honor.
Got excited there for a second.
I know, sorry. Dressed very similarly, and then I realized, nope, it's a code suit. I'm looking at the wrong person.
Suits, no glasses.
Have you watched Good Morning thus far? It's been a little. Like the fact that I still know what cases I'm calling is.
You got some, one, two options.
Oh, stop it.
That was on Mr. Jacobson.
Thank you, sir.
So ready to go on Mr. Gilliam.
Thank you, yeah. Although I think I don't have a full nollie, Nathaniel. None of us charges here.
Is it a 2-page nollie?
I have multiple. I have like 4 counts. You have the right piece.
Yeah.
Okay. Yeah, I have 4.
So I'm going to call to the record docket 22-01432. People of the state of Michigan versus Derek Devon Gilliam. Will the parties please introduce themselves for the record?
Thank you, Honor. Aaron Housefield on behalf of the people.
Attorney Zach Bonham, on behalf of the defendant, who's seated to my right.
And sir, you are Derek Devon Gilliam?
Yes, sir.
All right. Ms. Housfield, this is the time set for preliminary examination. How are we proceeding?
Thank you, Your Honor. At this time, the people do not have the appropriate witnesses to proceed with the preliminary examination and are moving for a dismissal without prejudice. I have a nollie that I will present to the court.
And Mr. Bonham, is that your understanding of what we're doing today?
That's my understanding, Your Honor.
May I briefly inquire your client so he understands the nature of the dismissal?
Absolutely.
Sir, you understand that the prosecutors moved to dismiss this case without prejudice, which means that they could refile the case if they want, okay, if necessary. However, at this time, the case is dismissed. Do you understand that?
Yes, sir.
All right. With that understanding, anything else, Ms. Housfield, for the record?
Sure, Your Honor, thank you.
Anything, Mr. Bonham?
Briefly, my client is wearing a GPS tracker. Can you report to probation today and have that removed?
I think we can. No? When does that?
He has to go to county,
So they'll remove it at the county. And yeah, and so we'll give him a nollie and he can take the nollie and they'll remove it at the county, okay?
May I approach, Your Honor?
Yes.
Thank you.
So what I'm signing now, get a copy, my court officer will make you a copy. You take this to the county and they'll remove the tablet. Thank you, Mr. Bonham.
If you refile, let me know. Reach out to you
This
first.
was
I understand. I tried to call him, his voicemail box isn't set up, and I sent him an email.
All right.
Asking him to log back in as soon as possible.
So what file are we?
I'll take Your Honor. If I can find Mr. Abbott, if he has not got pulled into another courtroom, I would like to run Heather Jenkins.
Okay.
Somebody go grab a car. Gotta get the plate. I'll make initial contact. Hello. Hi. Are you able to roll the window down? I'm Officer Mapley, Lansing Police Department. We got called over here because somebody thought it was kind of suspicious that you were hanging out.
I was just organizing my car and the process of moving, that's all. So I just put stuff in order.
Okay. All right. Do you
I'm actually done now, like I say, I got a bunch of boxes, so someone in the car.
Okay. Do you mind keeping your hands where I can see them step out of the car just for a sec?
For what?
Because there's a crack pipe sitting in the middle of the console there. I'd like you to step out of the vehicle for a second. Okay, so here's the deal. Step out of the car. She's trying to flee and starts another. 35, she's driving off. She's gonna go out to Butler. You got another unit close by.
Is there another unit close by to Butler, Iowa?
35, she's going west on Shiawassee. Right now, reckless driving. She had some drug paraphernalia in the car too.
Thank you.
Yep. So
I would have made a difference.
thank you, Mr. Abbott. And that technology is interesting to mark something that is illusory in nature. I'm not quite sure how that works either.
Court of Appeals will rule at some
Right.
point.
I did make a record. I indicated what everybody was watching. But technology and the digital nature of files, it's not a jump drive, it's not a disk, it's something other than that.
Yeah, thank you.
Thank you, Mr. Abbott. All right, we're back on the record in docket 22-01268. People of the state of Michigan versus Christopher K. Fisher. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Fisher.
And this is the time set for preliminary examination. Mr. Fisher was here via Zoom, and we started it, and then we lost him, but he was here. And I know that he had the opportunity to speak with Mr. Nickel in a breakout room.
Yes, and I spoke with him, and it was our plan to conduct a no contest plea to a misdemeanor charge. He was ready and willing to do that, but we have lost him. I haven't been able to get back in contact with him.
Correct. And so, Ms. Housefield, how we proceed? What is the people's preference for proceeding today?
Thank you, Your Honor. This case does involve a number of witnesses who have appeared now twice last week and then today. I would hate to have this matter reset for preliminary examination to have the witnesses appear again. I believe that we have reached an agreement on a plea. I would either ask that the court just set the matter for a plea on either a misdemeanor Monday date or on a felony day if the court so prefers, or if the court wants to have it set as a preliminary examination, because arguably he still has that right and we have not addressed that yet. I would ask that it be noted for the record that the people do not intend to bring in witnesses.
He did waive his 21-day right, so we're good on the 21-day. Mr. Nichols, do you have a preference? I'd be willing to set it for plea. I think we can set it for plea. I just like it to be live.
In person, you mean?
Yeah, in person. Yeah.
I would prefer to set it for a plea then if for some reason the plea does not go through, then we can set it for a prelim. But I agree. I wouldn't want witnesses to come back in.
Right. I don't want witnesses to come back if unnecessary. So we can set it for plea on a prelim date, or we can set it on a Monday. Yeah. And what's the just so for my notes?
Yes, of course.
What's the plea
He's
to?
going to plead to an added count 2 of B&E motor vehicle less than 200 pursuant to 750.356A2A. It's a 93-day and/or $500, Your Honor.
And that's your understanding, Mr. Nichols?
That is my understanding. It's also my understanding that the victim in this case is not seeking restitution.
All right, and it's a no contest, right?
Correct.
Yes, I'm sorry if I said guilty, Your Honor. I just need to say no contest. Upon consideration or in consideration of that plea, Your Honor, the people will move to dismiss count 1. Okay. And it is correct, Mr. Nichols' statement that there is no restitution being sought.
So the date of plea will be?
July 11th at 10.
July 11th at 10 a.m. and that'll be live, just so we don't have any misunderstandings. So July 11th at 10 a.m. Live plea.
All right, and I will let Mr. Fisher know to be here in person at that time.
All right. Anything else for the record, Ms. Housefield?
No, Your Honor, thank you.
Anything, Mr. Nichol?
No, Your Honor.
Okay, that's all on the record in 22-01268.
Thank you.
Email.
We can throw that. That's for the no contest plea.
Yeah. Yeah. Okay. Okay. That's kind of what I did. So by my count, Your Honor, we only have Richards left, Does Your Honor have other files?
Yes, but I think they're all taken care of. I've already signed Ollie's for those, so.
Okay, very good. So we intend to run, Richard, Your Honor. May I just have a quick?
Alonzo Jones?
Oh, this is Mr. Abbott. I think he and I worked it out and failed to tell the court.
All right,
Would you like me to grab Mr. Abbott quick bike?
quickly, yeah.
Okay.
And this is Hill and Page. We had knowledge on those, right?
$500 in restitution to the victim, Michaela Reed. I will provide a restitution form to the court before the end of the proceeding. In consideration for that plea, Your Honor, the people would move to dismiss count 1, the felony home invasion in the second degree.
All right, Mr. Nagel, I'm gonna indicate the agreement for the record, and then you can confirm it for me, so I make sure I have it.
Yes, Your Honor.
There's a no contest plea to count 2 MDOP building, and that is MDOP 200 to 1,000,
That's correct, Your Honor.
with a plea to the 200 to 1,000 pursuant to 750-380.4A. The count 1 felony count of home invasion second will be dismissed. There is restitution to be paid in the amount of $500 pursuant to the prosecutor providing a restitution form to a Michaela Reed. Is that your understanding of the plea?
That is an accurate statement of the plea. Yes, Your Honor.
All right. And this is a no contest plea, so we'll start just with the advice of rights in regards to the misdemeanor. May I inquire of your client?
Yes, Your Honor.
All right. Sir, you understand this time set for preliminary examination. It's my understanding you're going to be pleading no contest. Count 2 of malicious destruction of building 200 or more, but less than 1,000. Is that your understanding today, sir?
Yes, Your Honor.
And instead of having a preliminary examination day, you're going not to have a preliminary examination, and you're going to plead to that misdemeanor count. Is that your understanding?
Yes, Your Honor.
Okay, so it's a no contest plea. If you do a no contest plea, you will not have a trial in regards to count 2 in any way. Do you understand that?
Yes, Your Honor.
All right. These are the rights you would have on that count 2 misdemeanor count if you did go to trial on it. All right. You'd have the right to have witnesses called in your defense. You have the right to cross-examine all witnesses. You have the right to testify or remain silent without an inference being drawn from your silence pursuant to that case. You have the right to the presumption of innocence in the case, and you have the requirement that your guilt be proven beyond a reasonable doubt to all the elements of count 2, which is MDOP in this file. Do you understand that, sir?
Yes, Your Honor.
And you're waiving your rights to go to trial in that matter. You're willing to plead no contest today.
Yes, Your Honor.
All right. I will be using the police report for the factual basis. Is that correct, counsel?
That's correct, Your Honor.
Yes, Your Honor.
All right. And the purposes for the no contest plea are and so I'm gonna have you raise your right hand. I don't have to swear you in. So we're stipulating that the factual basis will be an LPD report of 2151906650. Is that correct, Ms. Housefield?
That is correct, Your Honor.
Mr.
Thank you.
Nagel?
Yes, Your Honor.
All
That's
right.
correct.
So let me review the report, and then I'll indicate whether you met whether the report indicates the factual basis for the no contest plea. All right, in regards to count 2 malicious destruction of property, I find the LPD report of 21519066650 indicates a factual basis in that the defendant did in count 2 at the fence location of 2337 Romont Avenue, City of Lansing, Ingham County. It appears did destroy or intentionally destroy a building or a related building. There's an indication that there was a rear door that was kicked that went inside the home. There was also, it appears that there was a window that was hurt or damaged. That was located at 2337 Romont Avenue, that being the property belonging to Michaela Reed. And the amount of the destruction to the building, which was intentional per the police report, was over $200, less than $1,000, and there's a stipulation of restitution of $500. That is a no contest plea. 1 year is the maximum penalty under $2,000 pursuant to 750.3804A. So you are pleading to the maximum penalty could be 1 year and or $2,000. Do you understand that, sir?
Yes.
Okay. Any questions concerning the factual basis of this House bill?
No, Your Honor, thank you.
Anything, Mr. Nagel?
No, Your Honor, thank you.
All right. I find the no contest I find the elements of the count two to be part of the record as a no contest plea to meet the elements of the offense. I think that we'll probably direct this to probation for a referral to probation for a pre-sentence report. So, Mr. Richards, it's just, I'm referring you to probation. You should probably go there today or as soon as possible. And they're going to ask you questions. It's for a report to be developed for me for sentence. Okay. And then we'll give you a date for that date. Okay. Be as candid as you can with them. And that'll indicate for me, with an understanding that you can get up to a year in the county jail and or a fine of $2,000. I want a report to be able to review the report so that I'm ready to pass sentence on you, okay? What's the sentencing date?
August 1st at 9.
So the sentencing date will be August 1st at 9 a.m. And Ms. Houseville, did you have a restitution order for the court, or at least for the file?
I do, Your Honor. I just want to confirm off the record with Ms. Reed where she would like this to be sent.
Okay.
So I will finish filling this out and then present it to Your Honor at the conclusion.
All right, just as long as it's part of the file.
I have it prepared other than an address.
So I'm referring you to probation for pre-sentence. It sounds like you're going there today.
Yes, sir.
Okay. I'll keep the factual basis in the file. Anything else for the record, Ms. Houseville, on 22-00284?
No, Your Honor, thank you.
Anything, Mr. Nagel, on the file?
No, Your Honor, thank you very much.
All right. Good luck to you. We'll see you on August 1st at 9 a.m. All right, thank you. 22-01488. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good afternoon, Your Honor. John Abbott representing Mr. Jones. He's present and seated to my right.
Sir, you are Alonzo Jones?
Third party voting, of course, as being Alonzo Jones.
Okay, so all you have to say is yes or no. You're Alonzo Jones?
Okay, yes.
Okay, thank you. Ms. Housfield, this is time set for preliminary examination. How are we proceeding today?
Thank you, Your Honor. The people were made aware recently, Your Honor. Let me back up. Your Honor may recall that when we were here before the court on the 24th of June for the scheduled preliminary examination, the people at that time indicated that the complaining witness victim was was on vacation. I had no further information at the time, sought an adjournment. The court granted the adjournment over objection and indicated 1 week. I think we all thought that that would be sufficient. Vacations are generally 1 week. However, once that date had been set and I reached back out to the complaining victim, she advised me that she was in California with her husband. So we have essentially two material witnesses in this case that are together out of state, and that they would be gone until the 5th of July.
Okay.
I let Mr. Abbott know that, seeking an adjournment again. Had I been aware of that information last week, Your Honor, I would not have, the one adjournment that we had, we would have used for an appropriate time frame. I just didn't have that information at the time. So I stand before the court again today, seeking an adjournment for a good cause. The people cannot proceed in this case without the two material witnesses, certainly asking them to return from California in the middle of a pre-planned vacation would not be an appropriate way for this case to go forward. And so I seek an adjournment.
Mr. Abbott.
Thank you. We strongly object to any further adjournment, Your Honor. The defendant is currently on a parole hold, so he's not getting any credit for the time he's in jail. The people have had plenty of time to get their ducks in a row, but they claim that their witnesses are out of the state, out of the court's jurisdiction. We request that the court dismiss this case, and if the people intend to reissue that, I guess that's up to them at some point when they actually have witnesses.
So it was initially set for June 17th, probable cause conference. And then the PC was held on June 17th. The arraignment in this file had to be June 6th. June 6th, June 17th, the first probable cause conference was held. And then June 30th, after the understanding that there was a week adjournment because the witnesses were unavailable for what we believed at the time was a date passed, and now we understand it's July 4th. They'll be back July 5th. Is that right?
Correct.
All right. So sir, you understand you have a right to a prelim within 21 days. Do you understand that?
Oh, yes, I did understand that.
Okay. So you still have that right. I'm going to accept that this examination is adjourned for good cause. Prosecutor doesn't have witnesses who are out of state, which is good cause in this matter.
Oh, because last time
I'm not done speaking.
if I have a chance to speak, I can't raise my hand. But
Right. So I'm going to adjourn this matter until and we'll do it. July 5th is Tuesday, right?
Correct.
So you can get them here by the 7th.
I would imagine that I can.
Yeah.
Other than their not physically being in the state, I've had good communication, response by email and phones, and I firmly believe that if I advise that the court has reset it, that they will make every effort to be here on that
So
date.
it'll be July 7th. Okay. So it's the fastest date possible I have is reset for July 7th at 8:30 for preliminary examination. And then at that time, if the witnesses do not appear or we have a problem, the case will be dismissed. I mean, that's the time I expect that we'll have a prelim on the examination. This essentially is the first adjournment, given the information we have now, okay?
That's incorrect though, Your Honor.
So you'll get a chance to speak, sir. So let me just finish this up. So I'm gonna reset it for July 7th at 8:30. 21 day has not been waived. And but good cause was shown. And Mr. Jones, you know that's my ruling, but I'll allow you to say anything you need to say to the court.
Okay, Your Honor. Of course, that means it'll be your ruling, but the people never, I feel that they can, it's alleged that they are out of state, but they're not. And the people should at least have some type of, you got all kind of computer type of stuff to prove that you're somewhere where you say you had. And they continue to use the same excuse. So we shouldn't be able to just assume that somebody said they're over there when they still running their business right now. They're not out of state. Okay. Now, furthermore, I would ask him, I would like to have my lawyer to address this, but apparently I don't know why he's not able to articulate this or whatever. But at this time, I feel that there's a subject matter jurisdictional defect, being that I would like to see the affidavit of probable cause. I was able to see this at the probable cause hearing. I strongly believe that based on the report that's been given, being the whole discovery, that there was never no probable cause for these two charges to be even sought against me based on the information that was given. And therefore I could have challenged the probable cause as being a legal search and seizure of my corpus. Because my complaint is not even signed.
Okay.
So I would like to see today by the people, the affidavit of probable cause. For oath and affirmation for this charge.
Okay. Anything else, sir?
The affidavit of probable cause is invalid, and at this point in time, I'm challenging jurisdictional defect. I would like to see. I have not seen it.
I understand.
But from all the evidence, I have the right to see the affidavit of probable cause.
I understand, and you will. There's a probable cause affidavit that was signed by a judge, and then that judge authorized your arrest based on probable cause. And then in Michigan, you're entitled to a probable cause examination within 21 days of arraignment unless there's good cause shown. There's been decided there's good cause shown, so you're going to get it next week. Next Thursday, you're going to get your preliminary examination, which is the second probable cause hearing to indicate that a felony has been committed and you're the person who committed that crime. Those are the rules, and we're playing by the rules. We're making sure you have a lawyer. We're making sure all your rights are covered.
So at the probable cause hearing, do I have the right to challenge the probable cause that was used against me to detain?
You are. Mr. Abbott's going to cross-examine any witness that is brought by the preliminary examination.
What is the probable cause hearing for?
It's
on the 17th, when I came to on the 17th.
We call it a preliminary examination to make sure that you're bound over to circuit court on felony matters, so that at a probable cause standard. The initial probable cause that you were arrested on was signed by a judge based on information and belief.
And I can't challenge that?
You can't challenge that.
I can't challenge a legal search and seizure.
You're going to challenge it next week. And you can file a motion in regards to any motions expressed in that. But once the judge reads the affidavit and then files it under our rules in the United States, those are the rules that we play by, and Michigan follows the majority of the 4th, 5th, and 6th Amendment. So, so next Thursday is the big preliminary examination in this case. Anything else, Mr. Jones?
An affidavit of probable cause.
I'm sure we can get a judicially signed affidavit of probable cause.
Right now, Your Honor, I'm challenging. There may not even be one. Of course, the court could tell
sir,
me
you
that.
wouldn't get here unless there was one. All
I've
right?
been in this situation before, and I feel that if the affidavit is invalid with information, then that should be addressed before anything occurs.
Correct.
Because if you use some lies to detain a person, then that's prejudicial to me.
You're going to have your day in court next Thursday. We'll get you a signed affidavit of probable cause. That's not a problem. Anything else on the record, Ms. Housefield, in 22-01488?
No, thank you, Your Honor.
Anything, Mr. Abbott?
No.
All right. We'll see you next week, July 7th at 8:30 for the preliminary examination. Thank you, sir.